94.7 Asempa FM. So near Ekosiisen Jumedie and Wasugusua Utiene. In 3 minutes' time, it will be 5 p.m. Here in discussion segment, no. So enti Munshan and some famayen. The start of the show, made it to just edne kukudam for me no be one awoda. First, elder of the Church of Pentecost, national chairman of the NDC, Elder Samuel Ofosu Ampo for NA and Awoda. Happy birthday to you. The Honorable Samuel Ofosu Ampo for Ekosiisen the CEO 1, Chief Executive Officer of Kumasi Asante Kotoko, Africa's Club of the 20th Century, Nana Yao Amponsa NA Onons Nawoda. Happy birthday to you once again, my brother. Live to be 94.7 and beyond. We wish you very, very well. We hope the job you've started with our dear club, no, you take it to the next level. Na bibia etumi akoye yedase papa. Ma yenhwena fe yemra emra metwa yen common so monso amudi ma woda na a ene yenya mudin amfa antudwa no yemamu nyina awoda pa enti munhye nso emayen. One of them Victoria Mawusi or Victory Bible Church International Dominion Sanctuary, Awoshi Bayard. I'm told you are a crazy loyal listener of Asempa FM. And happy birthday to you, Victoria Mawusi of the Victory Bible Church International Dominion Sanctuary, Awoshi Bayard. Happy birthday to you. We so another birthday dedication, Miss Braille Sky of British International School Year 2. Wishing you all the best in life and God will see you through. This from Adrina and your little sister, Lady Alvira Maya. Hey, happy birthday to you, Miss Braille Sky, and Braille Sky. Or British International School Year 2. Happy birthday to you. Ma yemra na fe yemfa yenkomono into me and shesheso. Lawyer SAMMY GYAMFI ma memra na yenhwe enra. The Supreme Court delivered its ruling on a matter brought before it. One, the constitutionality of the budget approval, and whether the deputy speaker, while presiding, and or you allowed also be a part of the quorum for decisions to be made in Parliament. And Supreme Court, you are ruling about. We are yet to see the details, but initial ones now, I'm also told that Omanpenyi Akasa ewo enra ruling neho enche mebo sa voice no de amamo na munsumehu what the president thinks about the ruling yesterday. Sammy
Obi medase edi kai ma menchia me colleague panelist honorable na menchia Ghana for omajebre we chichi ni benche ATM we fidi kesi so enumere. Supreme Court decision about Bontenra adi wo mu nyina ne se Ghana okoye mrahye bedwamu a otitinani a wo ho a ye frɛ no speaker na be di akirifo mienu no se omutie adwam na omohwɛ parliament inkita hodie parliament dwumedie so a omo wo ho kwan se omutimi tuaba e wo mrahye bedwam omo wo ho kwan se yetumi kan omo as part of mrahye bedwam for dodo we wufi ho a emra na se wo se yenya ansana Ghana mrahye bedwa etimi esi agina ya omatimi atake decision. And the Supreme Court decision abano.
Yes.
Ansana semi babe court no ihu ntokwa ene oyena esi mrahye bedwam. Emra na 2022 budget mrahye bedwa for abobo hu awie no mo to so aba. Eno mu ne hu se otitire ni ewo Ghana mrahye bedwam na bedi akire eye first deputy speaker honorable Joe Wise Joe Oseusu can say ruling on voice votes so and don kuma no a challenge ni ruling no say Mr. Speaker voice vote here was say yes for any denchen ya ye can no yempene so na mra no so say yempene so a yetumi challenge ema ye kan nipa ni biem through division or head count nti o accept this challenge ne say enkoso no e no no ka say oye mrahye bedwani nti no ono so beto aba ena donkuma ne ka say da bi ntumi nye referee ensan so nye player at the same time ani nye ye enu nti tena soro wa as otitire ni a ona otie adwemu a wo hwe parliament dwumadie so and descende emma pitch ne so emeka ball ne ho as a player eno na mentime ho ase ba ya de ntokwa ba tiene na mu ana opanyi bi e de asem ne kodo court se court hwe na court enchirichiri boni bi ani musa na mum de e de kasa bebre e de eyaudie ene abufuo aba e atemu a ye courts kese Supreme Court de abade afasa asemo yo and court na asemo a woka no a misi su biem ni nyina ne se uyo titire ni abedi akire a wo mrahye bedwam na wote punuti na wo hwe se mrahye bedwa adwuma be koso a while presiding no utimi to aba ema ne yeye obi enya nwanwa se Ghana fo bibreti kwa pai was asemo ho because asemo a Supreme Court abeka no ento asumu that is it ento asumu odwen ho a wonti ase there cannot be any justification for it and pay or akasefidifo for so me can say potoka semuno I will describe this decision by the Supreme Court as patently unconstitutional and logically flawed and in fact an unholy intrusion upon the functions and independence of Parliament. Na me cheche mu twikasem na mo mutie no atemase. Hwe obi ka kire wo se Parliament ede ne ho. Na Parliament betumi aye de opebia na obetumi ahye emra opebia court ntimi nka ho hwe a sinihu oboa. Because Ghana the idea adwuma wa ha no e rule of law emra na ye adwuma na obi biara so hye emra se yamamu no ye mu nkurabata miensa mrahye bedwafo mo na ye mra executive a eyo mampanyi ni nasoafo mo ne buman na nkasa ene ye wo judiciary eye chief justice ni ajagefo a omo no mo kyerɛkyerɛ mram enforce mra e wo Ghana sa arms of government yi nyina no eye yamamra 1992 constitution ene mra hodo a Ghana mrahye bedwafo aye ena establish enti sa amamuo ne nkurabata ne impenyifu edi animu ni nyina hye mrase enti Supreme Court okura hye mrase Parliament hye mrase ti se Parliament ye bibi na etia mra etia Ghana ya mamra Supreme Court wo ho kwan se omo kyerɛkyerɛ sa mra ni omo kyerɛ se Parliament we amaye di etia mra enti yabo atoagu Article 12 and Article 2 Article 130 are very clear the constitution and the Supreme Court are to me and also nti any Article 11 and Article 11 no echere Ghana emra hodo ayewo ene ni didiso emra no de he na to me ayewo mu no esopa de he na hyase ndu ko hierarchy of laws na ye say emra ewo Ghana nyina no de na hoden wo soro pa no ye 1992 constitution ya mamra no ena de edi ho no ye emra mrahye bedwafo ye acts of parliament ansa no wabasa subsidiary legislations ni ye keka ho nyina enu nti no se parliament ko ye mra ketwa na sa mra ketwa no ene emra kese 1992 constitution ni bo abura Supreme Court wo ho kwan so mo ka se we de emra we ye ntwawie enti ye twam ya hyegu what tell me na say enti obia ni wa waka se Parliament is sovereign. Parliament then who to be emra wope. Nobody can make that argument. But ansana Supreme Court beka say Parliament aye bibi ana parliament ashemra na samra no omo boagu no e was samra na parliament share no any bibi e wo ya mamra ni mu boabura. Obi, are you getting me well?
Me too.
That law can only be declared as unconstitutional and for that matter null and void if it is inconsistent with a provision of the Constitution. Okay. And unti asemu aye ke nyina efa ebeye den whether or not obi a oye deputy speaker our parliament obetimi ato aba no efiri hin e bae yenti ase you parliament and our 1992 constitution ni mu a article 110 amani to me say and I'm say ye twa constitution enye bibia na ye betimi atwere ne wo mu enye mmara ye de be ye adwuma various institutions de be ye adwuma nyina na ye betimi atwere ne wo mu enti ya pone to me bia ma mrahye bedwafo say mumu mmara mumu fie ho no mrahye bedwa mu ho no mu de be di mu dwuma no mumu nye na engave mu dwuma mu be di ne mrahye bedwa fie Ekosiisen article 110 betimi akan amamia obi
1101 was subject to the provisions of this constitution. Parliament may, by standing orders, regulate its own procedure.
Neche se parliament betimi ayem right when you find standing orders. Na omo de sa standing orders no. Eno no mo de be chichire, eno no mo de be di omu dwuma wo mrahye bedwam. Constitution na data to me na mo. But the first phrase na was subject to this constitution. Yes. It is amra na wo ye ni nyina no. Se eni bibi wo 1992 constitution mu bobra. Ene na sa amra no. Enya papa. E was Supreme Court bebogu.
Yes.
Enti based on that to me where constitution the ama mrahye bedwafo no. E na mrahye bedwafo 92 o matena sese. Ye mra ye di be di dwuma wo mrahye bedwa. And almost say, yeah, dear, you can Mr. Speaker, order 7, honorable order 7. The honorable bit me their femwa. Nanka what kind order 7? You can order 7 now. Mr. Speaker, any will be or preside over Parliament. And he say, yeah, Mr. Speaker, now the 2 deputies, and now 2 deputies in Niwa, ordinary member of Parliament or presiding, or Munina, Mr. Speaker.
Me too.
And I was saying, Mr. Speaker, wona wo be kwa for konwa kese na tena soro. Wona wo be hwe parliament dwumedie nyina so. Obi sori gina ne nan so a wona wo be frɛ na ma ne kwansa na watumi akasa. Obi di motion ba wona wo be rule on the motion say motion we di mu ana enimu. Wona wo be bo agu ana wona wo be gye atum. What you say? Obi person file motion kra to admit the motion who speaker no ana wo a wo preside no. Say we member, say we deputy, wona wo sa to me no. And until no mrahye bedwafo say wo no yempese wo de ho be fore enyema parliament ebobo ho abra wo tie dwam se wo tie dwam dia ene wo nya Mr. Speaker be wo nya kotere dwam a parliament for say ye nyansam no wa be ye Mr. Speaker se wo ye NDC ni se wo ye MPP ni e wo say afanfa ne mrahye bedwafo di nyina e de obuo ene didie ma wo etutum say Joe Wise ye konwa mo ye MPP ni pa ben DC for kasa ne ho aye de obuo ni didie ne ma no Mr. Speaker o ma order obi adi akire he is not treated as a common MPP MP and it is the same situation if Senka deputy speaker to also ye NDC sa so na MPP for the need be den e be ma no because wa fro konwa kese no ono kra wotumi se obetumi order say wo mrahye bedwani bi wo ye niamo ho sem wakasa kire wantie enti marshals no security fo a omobo ban wo mrahye bedwam o metumpi abonti enti wo obi wotumi ye enti mrahye bedwafo no ye omomra no mo se sa nipa kro we de yempese even though so be one party NDC and MPP no so tia konwa ni mu a yepese o ye neutral enti wo ko order 9 omo se di otia konwa mu no I am Mr. Speaker no oni ho kwan say parliament debate a wo debate bi tieni yo even though that Mr. Speaker can be a deputy speaker or ye MP no ho constituency no macha bedwafo say there be yem pese ye debate obe debate bi because ono na ye referee ono ye panyin pa judge mu a ote akonwam onye neutral onyina mfimfini ena omuko section order 109 3 and almost say constitution ni dia aka ne dada say Mr. Speaker pay mu na nkasa de ono onya mpimpo nti ono nto aba e wo parliament so ti ase
yes
Enti we deputy speaker wo so no we need to me say otoaba. Even deputy speakers ni mmarahyɛ badwafo more constituencies. Enti order 1093 no mmarahyɛ badwafo de ahya was say we deputy speaker o to be to aba as an MP. But when you from betena soro na wo preside dia gina finfin untumi ntoaba. Eye mmarahyɛ badwafo na de ahye omo standing order musa. Ene no ne ye de aye adwuma wo Ghana ha for the past 30 years.
But no say any provision be asa in the constitution.
Dem pacho tie me me kaba. Say provision bia e was say ba subsidiary legislation me was say wo parent law mu and there will not be any need for subsidiary legislation. That thinking no and until I say am more kasa I don't know whether omunya nto bo ase me de omo ka no dia. Say was say bibia wo constitution mu dia and there hiya be ne hiya bi say parliament yes standing orders. Parliament me pacho me ba.
As part of the ruling, you know, Oma call it for say parliament any sa.
Anything I make sure what they make asem ne ba. Wo betem ase.
Okay.
Eti parliament for na constitution am mo kwan so mutimi ye omra. A omo de bedi omudwuma wo fie. Sa mra no entimi ni constitution mo abura. E na oma ye omra order 90 uti adwamu a wuntimi debate wo ye MP wuntimi debate. E na oma ye mra order 1093 say uti adwam na your deputy speaker even though say we MP ntimi ntoaba and ye this had na di adwuma from 1992 besi na almost 32 years in almost 30 years ni obi uti de meka ni ye after the 2022 budget by na buy na person or passing at all cost 11 tax e ba be ku Ghana for ntia all of a sudden MPP for say the we deputy speaker uti mitwaba. This is the first time this issue said deputy speaker to me to Aba because of your MP or constituency. A failure since 92 Aba, all because of e-levy. A same way near the Akoma courts. The Supreme Court for Komoso order 1093 say deputy speaker to me to Aba. Parliament na any constitution ni bo branch o mashiegu. TME. It me first question ni. Omo defend this Supreme Court decision say papa no. Omo nkyere me article provision by the 1992 constitution mu order 1093 na say deputy speaker ntimi ntoaba no ene ne bo abura omo nkyere me one
na say and I asked lawyer Joe Gatti this
question.
Question
Answer
the response and it said there is nothing in the constitution so I can say will be a deputy speaker ontimi ntoaba
ti use common sense no logic bibi wo constitution mu e say deputy speaker preside a ontimi nye debate
in the constitution.
Yes.
Which
me say
article? No.
Maybe constitution where say while presiding no
you cannot
a member of parliament who is presiding as a speaker or a deputy speaker on to mean participating in debates.
No.
Good. BBNim. And so standing order 90 is Musa honorable Meboa.
Okay.
And yes, I know your own constitution and Mungu. And ye Bibiana was a what constitution say Emrebia was a what constitution yeah. Subsidiary legislation na ye there is a lacuna no na lawyer for friend lacuna no ma make be intro ebi mo ka say bibi wo constitution ni mu expressly a say deputy speaker ntimi ntoaba omoboa ebi mo ka say bibi wo constitution ni mu expressly say deputy speaker ntimi toaba eno so omoboa the truth ne say o kan 1992 constitution from A to Z bibia ni mu a eka say deputy speaker so ti adwamu preside a utimi to aba ana untimi to aba enim sa
enim yes
expressly enim
yes
and at best the obetumi aye ne say because when you are interpreting the constitution you interpret it as a whole obehwe constitution anka say deputy speaker ntimi to aba and anka so say deputy speaker betumi to aba enti utimi hwe constitution afafa bi ne nsem bi aka na wagina so in interpreting the constitution as a whole no impliedly we watch the wadwen won say me free say deputy speaker ntimi ntoaba me free say deputy speaker ebetimi atoaba are you getting me but no any constitution no verbatim are you getting me
yes
so Supreme Court to say order 1093 mmase bedwafo na aye de omudwuma for 30 years ni deputy speaker bi antoaba da no omo say enye mra papa na deputy speaker would to me say utimi tuaba and I say Supreme Court for betimi akasa only if that order conflicts with a provision in the constitution.
And by provision, you mean an express provision?
It must be a provision in the constitution.
Express provision.
Yes, it must be it must be a provision in the constitution. For example, if the constitution said that a deputy speaker can vote, and parliament do a standing order and say a deputy speaker cannot vote, that standing order is unconstitutional.
Unconstitutional.
So where in the constitution and a constitution is a deputy speaker between atuaba? So this whole argument say parliament is not sovereign, they are under the court. Right. But court so na court
of course.
Court will also enforce mra. Say parliament a shemra ne ya mamra ne bobura obitu sande de obitu ahye samra na gusa nyamra papa. Enti we am ahye gu any provision be ne bobura. Obi me maka no cry say bibia ni constitution we say deputy speaker ntimi ntuaba and a deputy speaker bit be atuaba. De ye nyina ye no.
And based on that no nyini say parliament express provision in their standing orders without any constitutional backing. Say deputy speaker are representing Kofu Atuaba mano entimin Tuaba a monumental decision. I should
regulations
have in the constitution.
Regulations and subsidiary legislations. It provided for gray areas. It provided for even things that the parent law may not have provided for. Because in the parliament, any parliament for Nankatabe regulations are constitution and Katabe regulations are my parliament. But they can do standing orders where all there's a womb about 200. Tikani na beshe constitution ni mu. Sa standing orders na wom no. Okohe order 2115. Yes say parliament ye adwuma in committees meboa. And yes say committees no. Your yet ni wo chairman no. The committee ne to aba take a decision or no only original vote on to aba.
But casting vote.
Yes, casting vote ne say omo bracket yes one an ye ka no abane paya or no timi to be to so. Ono abonya za na moye no. Chairman no onye MP. Only constituency. Other na parliament for ayemra say ontimi to aba original. Ontimi only original vote.
Na nye oye MP need to know casting vote.
I didn't know hold on.
Chairman role ni speaker of parliament role. Almost the same at the committee level, but the speaker has neither a original or a.
Now me say, what the first speaker Antonio because no MP. Muna mo say obi o MP bia no because of representing constituency in the water to aba. Me say adenti e na woko parliamentary committee a na parliament di omujuma ankasa. Chairman no ye to aba want me to be just aba na payansa. Because you say honorable mebo, because you say parliament for person just say we titire ni wo ho no. E was say we neutral. And also we impartial. It won't to about be paid ya with me to be. Are you getting my point? And we constitution. If you're not so someone can say your own constitutional because parliament I a standing order. Yes, a chairman of a committee. Only original vote and also Supreme Court in Mungu because a new constitution. That is how warped in logic this Supreme Court decision is.
But has anybody brought that before the Supreme Court?
The
Supreme Court
if the Supreme Court is going to do that, then standing orders 90% because 90% of the standing orders in the constitution.
Ekosiisen on assembly.
90% of the standing orders in the constitution. One body be institution be to me say onyemra and govern or no ni procedures in parliament. Why mra? Any bibia ewo constitution ni mu mabura o se mahiegu because any constitution ni mu na se mra na o se omonya ni nyina wo constitution mu ene omo ye mra for Friday di omo be ye no ye den dodo na anya den e ma constitution ni mu obi utie mi ye
me too pa.
Some of the things are repetitions of constitutional provisions. For example, the provision said the speaker shall have neither an original or casting vote. Constitution.
Absolutely.
It also was standing order. But the was standing orders anymore any constitution. It means now your own constitutional because any constitution. You call schools and so it comes to the American say Supreme Court decision, even without going into Article 102, 104, no, a fraud. Ghana beto ho me say we real koto decision free wa decision pa court no edi o man ni nya asay ye kabi mami kabi asay parliament kabi mami kabi ye wo mrashe bedwam eni
really
decision pa eye bad de basabasa ye beba mrashe bedwam eni Master, what provision in the Constitution does that order violate? Where in the Constitution did the framers of the Constitution say the Deputy Speaker preside to be Tuaba?
But
where number
what
one?
about when the detailed ruling comes out tomorrow?
Me say,
now proof.
Constitution,
how do you know?
You can't honorable person.
No honorable person.
He's a lawyer. Person of Boameka. 109. Standing orders. 2. Mr. Speaker shall have neither an original nor a casting vote.
Yes.
And if upon any question before the House the votes are equally divided, the motion shall be lost.
Yes.
Now 3. A deputy speaker or any other member presiding shall not retain his original vote while presiding. Why was 3 silent on casting vote? Why?
3 was silent on casting vote because where your constitution now has standing orders now.
Yes.
Ghana, you need to be a friend casting vote. Also, US in the Senate, where the vice president of US is the president of the Senate.
Yes.
See, vice president in your original vote, be a two about pie or casting vote. Casting vote on friend tie breaking vote. About pie into your teardrum no also. Oko board be breo.
Yes.
It get Ghana no over Article 104 now. Was a parliament. Your constitution no say parliament. Yeah, the assembly call near to about pie.
Ekosiisen
It is considered as lost.
Yes.
And if it is considered a loss, then it means
when the speaker is presiding.
No.
You see, the reason I'm asking is, who say a bad deputy speaker
No.
silent.
No, but me person me just say 104. No, me about Article 104, which is about decision making in Parliament, voting. Or say you two about Parliament that ban paya it is lost. Say yes, speaker and the say your deputy. Constitution is it is considered lost. Okay. So therefore, the issue of casting vote doesn't even come up. Are you get? That is why the Supreme Court is saying the deputy speaker has an original vote. Casting vote because I know the system of governance. So what I am saying is number one, South Supreme Court decision way a decision bonny decision banza because there is no express provision in the 1992 Constitution say deputy speaker while presiding utimi tuaba and a parliament for akwaye mra say ontumi tuaba for which reason musimo bo emra na gu nti samra order 1093 emra papa edimu now it is consistent with other provisions in that standing order because uti edwom na ye deputy speaker ontimi nka say me wo constituency ntino me ye debate ono abobit me akasa mo kasa mo ye debate and wa pagya onza my friend me ho my sorry agina my kasa we obi wo point of order Mr. Speaker point of order who make me raise point of order against Mr. Speaker eti say or your MPO so you say ontimi nye debate and then no dey yanka say no dey ye disenfranchise ne constituents because they will lose their freedom of expression yenti your money e parliament you say when you afura kosoro no wo ye ma to me ye ma wadodo de wo sa tu ade no hunti wo gina mfimfin it is argument na na obi we article 102 ade nti aye ye say even though the constitution doesn't expressly say the deputy speaker cannot vote yes say the constitution if it is interpreted as a whole no you arrive at the conclusion that the deputy speaker cannot vote and say article 102 say article 102 honorable ene na kire emrahye bedwafo dodo a e wo say wo mrahye bedwam ansa na parliament etimi atena se adi dwuma bi ama sa dwumadie no aye valid adimu se sa nipa dodo sa minimum number ni wa untumi kura enya de bia wo parliament na kampese wato aba eno na article 102 say sa quorum no nipa e wo say wo ho ansa na parliament etimi adi ni dwuma ama sa dwumadie na adimu no eye 1/3 of parliament excluding the one presiding, whether speaker or deputy speaker. On count, so 1/3 no on count. Yet the deputy speaker is an MP or constituency meboa. I didn't know what Bamrashe bedroom. Now you see a kind quorum, the minimum number of MPs who must be present.
I bet me share parliamentary business. I
said, near say, Ujinaho, Emma, Afigya, Kwabre, North. And so yen kind or encounter. I don't want MP. And your constituency being a Tuabamano. So only say where quorum is short by one vote. Say deputy speaker and president no you cry on tibin kan yin tibin kan kan on MP. If you want to argue say and deputy speaker and MP or representative constituency one man antwa I didn't know quorum ye gini free. Because yen pese dwumadi a ye ba bedi no fie ho no one ne ho be for the mu on na ye judge on na ye panyimpa or tipnuti, and you know on Kadumedina Yababedin will fear one home. And the young kind in Ponka. They say then I free 102. Now they do 104.
104.
When you are talking about decisions, sir, you know MPP for the Supreme Court for say. Sir, Deputy Speaker now. Yeah, kind.
Supreme Court na say.
MPP for that. Just Attorney General arguments or the coin of Majatum. And also any argument MPP for you. After the Supreme Court ni MPP for say. Deputy Speaker na or constituency or your MP. But yeah, kind call them young kind and can because on the MPs or mobile transacting business young kind and can it do time I take a decision. They are young kind and can near man on to aba. What's be that? Without a quorum to commence a sitting, would there be a vote? Can you have a vote?
We will not get to that point.
You will get to that point. So if the quorum to commence the sitting, how much the decision of that sitting? You are not part of the quorum which can allow Parliament to even commence a business. Even though you are an MP as Deputy Speaker. But a do decision was a man kind of a decision they may be. I said we are tossing. Sebi previous obi me mo bi animtia etasumu. So clearly no. So when we read the constitution as a whole, even though it doesn't expressly say the deputy speaker cannot vote, we are 102. Now the 104. You can see clearly say the framers of the constitution never intended for the one presiding whether speaker or deputy speaker to vote.
But don't you think, sir, if that was the thinking of the framers of the constitution, 102 specifically mentions apart from the person presiding.
Yes.
In 104, the framers were silent in 104.
When it comes to a quorum, law, no, they are not reading the law well.
How so?
Let me show you. Okay, read the first phrase of that 104.
Except as otherwise...
General, except as otherwise provided
in this constitution.
So if it has already been provided, the constitution will not repeat it.
What has been provided?
It has already been provided that the one presiding is not even part of quorum for Parliament to start business.
No,
and if he is not part of quorum, which is needed before Parliament can start its business, can sit, how can he be part of this? It flows from it naturally.
Okay.
And one thing I will use when you were interviewing Honorable Jogate said, is it not a sine qua non? It's 102, not a sine qua non to 104. It flows from it. If the constitution now, if you 102 know about 103, 104, 102 no what me said, what would you do? Uri padodwa eba bet sitting no kwa no yen kan won ka ho. Odu 104 am say wan san so anka say the oba be press the all preside no o timi nto abenti no and you betumi ato aba. It doesn't make sense that because that is why the first phrase says except as otherwise provided, and it has already been provided at 102 that is not part of quorum. How can you be part of a decision in a meeting whose quorum you were not a part of? Does this make sense? Now, Obi, in this argument, I can't be just 2-3 arguments. I'll do it in 2 minutes. And I'll be honorable Bebem. Ebi will say, oh, my children will say nobody is saying it's a parliament then wait my idea PBR. And I was surprised that lawyer Jogate, almost the ones who paying you for by so many years, who says, court, Supreme Court, I say, whatever happens in parliament is a closed book. I'm surprised because lawyer Jogate, they are authorities when it comes to the law. Yeah, they are more from marketing, or monase. So they are saying, and I mean, Sabia, on the mono is a baby or maritime. It may be a nanny refi, and Yamaka, men kind of need you. Obi to 4 versus Attorney General. That case, when is the president who for the lawyer Chachuchi Katana Yema delete Amwako to 4. And you know what justice.
But I don't know, it was on the 79 Constitution.
Then the 79 Constitution anyway. in so many forms. Because in that 79 Constitution, Parliament was not sovereign.
I know.
The powers of the Supreme Court to interpret and enforce the Constitution is the same. Article 118 of the 1979 Constitution is the same as 130 This is what he said. Justice Sowo said, this then brings us to the question of how far the courts can question what under our Constitution has been done in or by Parliament. To what extent can the court question what has been done in Parliament or by Parliament?
Yes.
So there is a long line of authorities which establishes 2 important principles governing the relationship that subsists or should exist between Parliament and the courts. A, that the courts can call in question a decision of Parliament, but that the courts cannot seek to extend their race into what happens in Parliament. And B, that the law and custom of Parliament is a distinct body of law, and as constitutional experts do put it, unknown to the courts, and therefore the courts take judicial notice of what has happened in Parliament. The courts do not and cannot inquire into how Parliament went about its business. This is Justice Sowa, Supreme Court judge. These constitute the state of affairs as between the legislature and the judiciary.
Ekosiisen on
Then what
SAMMY.
was or say, of particular importance to us are the provisions of Article 96 of the Constitution. They confer on Parliament freedom of speech, of debate, and of proceedings in Parliament.
Absolutely.
The article also says categorically that freedom shall not be impeached. That freedom shall not be impeached or questioned in any court or placed out of Parliament. The courts cannot therefore inquire into the legality or illegality of what happened.
Yeah, but the difference with 79 and 92, they say in 92, Article 110, as you alluded to, ECA says subject to this constitution.
Subject to that constitution.
Anything Parliament does, no, should be subject to this. It's clearly different from 79.
No, 79, the answer is So what this court said, and it said, if Parliament exercises that authority in accordance with the Constitution, no problem.
Yes.
But where they exercise it in contravention of the Constitution, the court can come in.
Yes.
But Bissau, and you can ask all the MPP lawyers who defended the Supreme Court decision, which
provision no?
They don't have in what business. Last but one, Obi. And apart from Tobobi and GBA Ghana Bar Association versus Attorney General, and also when President Rawlings appointed Justin Aban as a Chief Justice, Ghana Bar Association co Supreme Court said Justice Aban will need to buy Constitution is also Chief Justice was also buy pa. What did I say? In summary, the Supreme Court said they are appointing as Chief Justice no Usubampo, Unisubampo. And the Amani 2 minutes decided court ain't income. Ain't fair.
That's an interesting.
That's GBA versus
an interesting case in reference to the GYAMFI and AG and A plus and AG case.
That's the Attorney General case. That's that case. The only case they departed from this, and that is the doctrine called the political question doctrine.
The political question
is 31st December, MPP versus Attorney General, and GH-MENSAH versus Attorney General. And in all those cases, Parliament acted ultra vires the Constitution. Constitution CA normal B. What you say? But where Parliament and our President, the discretion, the court doesn't interfere. But finally, Obi. Finally. Omanpenyi interview now, what can I say? You see, in trying to justify the Supreme Court, we're going to be a better. Omanpenyi pa, law school near reading the Supreme Court constitutional law cases near the Omanpenyi say Supreme Court decision way papa. Na Ghana krano, okoye district assembly, presiding members never hono. Omotwaba. Omanpenyi kufu abne kai na ye pa. Yanko check district assembly law. Obi. Me de say MP a me ne wo studio. Why assembly member da? Meso my assembly member. So be unim that.
Now we are appointed assembly.
And I'm assembly member whether appointed or whatever. Honorable. You have me honorable Dana. You have me honorable. Once an honorable, always an honorable. Now over 18. That was just by the way. Over section 18. Meetings, that is local government acts. Na me kind share with you. Me person who is on my penny work back. Sani is one near cano. I say the district assembly shall meet at least 3 times in a year. Okay? Then the relevant portion, in the event of equality of votes, the presiding member shall have a casting vote. So the presiding member is an assembly member, but we need original vote.
Yes.
Or casting vote. Or manpenyikas or casting vote or boa. I feel manpenyikas or original voter. Presiding members to a bar. Me ko KME. Nana ko fi senya na presiding member. Want to abada because abada kram pai na abada to be.
But a casting vote is a form of a vote.
President of the Senate of US, the Vice President of US, who is the President of the Senate, Abapai was Senator to be so MP. It is the team out to casting votes, you know. It's not that you are an MP represent. President can interview. Last one, you have your try number 2. Try number 2 or say, Oko Yuka, the Speaker of the House of Commons of the British Parliament, or say the President of the British Parliament, or also Tuaba, and also say Antro. The House of Commons, the Speaker in UK on Tuaba, or also casting votes.
Yeah, that's it. Sammy, your microphone is off. Relax. Honorable, me pacho bremo. Na EMT on this particular issue. But answer now, lawyer Ejurita Maklo comes through with this or say, Obi, what is in Article 297H of the Constitution? In the 297, they care about implied powers. In the H, they say words directing or empowering a public officer to do any act or thing or otherwise applying to him by the designation of his office include his successors in office and all his deputies and all other assistants. And I don't know if lawyer is referring to the fact that when the Constitution says the Speaker shall have neither an original nor casting vote. In the Obi Obabe's name as deputy BN, this would apply to him based on this provision. I think I don't know. You will be acting as the Speaker. Fair.
Okay. Yo, Obi.
Yes.
Michelle. Now, and then the first time we share Sammy.
Oh, okay.
In studio, yes. Okay. Of course, but I think say what I'm happy about is the language, you know, quite decent. Unlike ruling by the mati free in NDC for we have social media, Facebook, attacking the judges. Abra sebi the reasoning of the ruling grammar. Now, judiciary is a very, very sensitive institution in the sense that the 3 arms of government, 2 are very political. Over parliament and MPP will be NDC. Into here, they will argue on that level. Executives also, at any point in time, one political party must occupy. In terms of very political. Into the end, a democracy the judiciary. And they say, Abdullah.
Yeah, Justice Abdullah.
Wako Supreme Court for an interpretation. No quite so. Sani say, Nese ruling ba. You can disagree with the ruling. But at MDD, no. And I'm telling me, Bonabaso say, the argument is based on law. Although some of the standing orders in the law are quote, I also disagree with him. I think say it's been done in a very professional level. Obi, me lawyer. Me metna and pretend they say minimum law no sense I GYAMFI and Nasabi. We law lawyer Supreme Court judges. I'm not sitting here to pretend to be more powerful, more knowledgeable than them when it comes to the law. They are me there, and they say we are going through a certain process in fulfillment of our democratic credentials. Set disagreement about parliament. Ni yenti ya mwase. Ni yako an institutional. Yen ya mandate to say yenti bibiya say yemra hono. Me they said that process is ongoing. And until na beginner make say yen members of parliament Libya, they've been very, very harsh. Go Facebook, and they say on the floor of the house. And then World Kidney Day, you know I'm on health committee. To me making statements on World Kidney. Just before I ever a debate on it. Then Minya Baku raised an issue of quorum. Quorum assembly can. But the way he was even referring to the speaker. Now, Right Honorable GYAMFI, Speaker of Parliament, instead of saying the speaker, no, I say, Honorable GYAMFI, trying to say, Supreme Court say, what the now I'm not going to refer to you as a speaker. And he was saying it, to the hearing of everybody. GYAMFI, MP for Bekwai. MP Bekwai. So also when you presided, he's out the MP for Bekwai. It's the message. me dear mechanic say me say me case me be dear some I'll be disagreeing with him. I say you'll be disagreeing with 102, 104, 102, 104. How can I don't know in one breath no he's not part of forming a quorum. And in another breath no he's part of forming. We can argue about that. You bet my argument and do argument. And they say they are Supreme Court. Supreme Court are pronounced. That for me, I said the mom lawyers, it's not final. You can go for a review of it. When the reasoning behind ruling when I think it's a better boy now to have an informed decision. It's remember me Abaso, his arguments and ADOMAKO-MENSAH. He disagrees, and I disagree with him on a lot of things. In fact, me now follow his baby. I saying there's some me cano lawyer. So they are trying to tell me that you quote here. No. You know, bottom line, if I quote her, it will be a disagreement from what he's saying. Anything in Supreme Court, he says Supreme Court to say, and you may be why your parliament and the way standing orders more unconstitutional. Some of you very interesting questions. Say, young channel, baby, constitution. And let me be no interview in your penny jogatin. Or say it's even inconsistent to the fact that ADOMAKO is not even nowhere in the constitution. That is what no argument. No. Oh, some is also there be and yes, there's one arbiter, which is the judiciary. Obianka na come Antonium. Or when the reasoning come. We inform ourselves so that going for a discussion a bit enriched. You meet my one.
Wow. Honorable, that's it. My main kind messages, Kakra. Now, you're more president voice no in me patch. True, president voice, my main your money and trust. But while we wait, no, let me read some few messages. Now, ya trust so Kojo Frimpong. Kojo Frimpong from Wenchi. Was it Obi? SAMMY GYAMFI is absolutely wrong. Debating, chairing meetings, and presiding over quorum are not the core duties of a member of parliament. Representation at its core is to vote on issues arising in parliament. For the MP to be denied a vote is for his constituents to be denied their right of representation in parliament. As for the other issues of whether or not Parliament is an open or closed book, they are tangential to the issue that Richard Sky and Justice Abdullahi took to the court. Kojo Frimpong. Obi, lawyer SAMMY GYAMFI is saying that the court cannot inquire about Parliament actions. He is right. But this time it was a Ghanaian who went to court for explanation of the Constitution. It was not the Supreme Court which sought to find out what Parliament does.
Ekosiisen on
the jurisdiction of the court should be invoked.
But if it borders on
the political question,
allocate an elected arm. Nasa elected arm no ejuma no munya ntieti amre bia so a. That principle say the Supreme Court should not intermeddle with that. The last one, Kwabena Sapon, the day no by Kwabena, thank you. Obi, ask lawyer SAMMY GYAMFI also to tell us where in the Constitution does it say explicitly that a deputy speaker cannot vote when presiding as a speaker. Yao Marvin, Kwesimintim. Good afternoon, Obi. In the U.S. Senate, the president pro tempore, who presides over proceedings is an elected member of the Senate. He is able to speak or vote on any issue, and in a hung Senate as it is now, 50 Republicans and 50 Democrats, the Vice President of the U.S. cast a deciding vote. Similarly, in the House of Representatives, as a member of the House, the Speaker is entitled to participate in debates and to vote. Ordinarily, the Speaker votes only when the Speaker's vote would be decisive or on matters of great importance, such as constitutional amendment or major legislation. Life is normally simple, but we make it complicated for ourselves. Can we make things easier in Ghana to avoid these divisive conundrums that tear us apart and concentrate on developmental issues that could uplift the standard of living of our people? Augustine Yao Agbeneza and Odewe Abba. Yeah, I'll give you the opportunity, don't worry. Good evening, Obi. Lawyer SAMMY GYAMFI has said it all.
the Supreme Court of Ghana should come again. Alfred Kojo Tredels. Obi, what is in Article 110? Lawyer Eduji Tamaklo. Lawyer, no, they say I can't. 110 na Emma Parliament to me is subject to the Constitution. My standing orders to regulate their own procedure. That is Article 110. Prince Henry in Koforidia, since Nana Akufo-Addo is defending the decision of the Supreme Court, he should also know that the NDC minority in Parliament will also defend the Constitution and standing orders of Parliament whenever the controversial e-levy is introduced in Parliament. The future is pregnant. Ejakwejo Ewa Dallas, Texas. Obi, greetings to my MP, Honorable Collins ADOMAKO-MENSAH. Very fantastic young MP. He speaks with facts and not propaganda. Obi, our judicial jurisprudence is being broadened each and every day. This ruling from the highest court of the land is a win for all Ghanaians. Our democracy is indeed a beacon of Africa, and we have to be proud of it as Ghanaians. Now, the duty of Parliament is to live by this ruling until we have a review setting aside this ruling. We really have a country to build, and some of these decisions by our Supreme Court would only go a long way to help this country in the long run. Goldie Ewo Tema. Goldie in Tema. Obi, a friend's opinion. A primary function assigned by the Constitution or statute cannot be ousted by a secondary function created by practice or some other rules not consistent with the Constitution. A primary function assigned by the Constitution or statute cannot be ousted by a secondary function created by practice.
Constitution. Did the Constitution create a primary function for a deputy speaker?
No, I think the point there, when you say oye MP, the primary function assigned by the Constitution.
But nobody is saying an MP cannot vote. You see, a deputy speaker,
who is an MP,
who is while presiding. But what about the post? Na MPs na woni nyina mu nyina na deputy speakers no unim. Because the post no your title keke.
No, any title okay.
It comes with a lot of privileges.
But so, he's first an MP.
He's first an MP. And he say, "Ube your deputy speaker, fine. With me too about whilst you are sitting in the chamber as an MP. Yeah. But while you are presiding, you have transited from the chamber. Now we say, would speaker come
speaker privileges.
And I don't know. Kind imply provisions. Natural say.
Yes.
The speaker need here was here. The speaker be was here. The man. The speaker to me ye be out to me when you are in that chair. But the speaker to me ye be as to me because what is our kunyamuno? To be referees and your footballer at the same time. Be neutral and impartial. Yeah, the same arrangement crowd committee level.
But said the speaker to me be a wound to me ya. Adentina speaker no on to me ya original, on to me ya casting. But who are casting?
Only casting there.
No, so we a deputy.
Na Ghana ha ye nia de be friend casting vote nti be na deputy nya casting vote. Ghana casting vote ne say casting vote ne say ye to aba ma ne paya. The otie adwamu no wo kwan so to aba ne o de decide be bia vote ne be ko. Ghana so constitution say ye to aba ma ne paya. That motion is considered lost. And casting vote ne it is already lost. Ye to aba ma ne pai.
The other point about because at the committee level the chairman represents the speaker at the committee level.
Yes.
You agree?
Yes.
Great. But the chairman at that level representing speaker, no, was casting vote. Only original.
I don't know only original. Is a deputy speaker some more king. Kofa Supreme Court verdict yabe. Say the deputy speaker simi to aban. A original vote was some yeka. To me the person made the casting vote because chairman on also original speaker na committee level no. Only original vote Joe Wise. On the chairman of appointments committee.
Yes.
Yeah, aba on to be.
I just apply.
I know the other yanka say, yeah, the same franchise be quite for. I don't know. Ono boy yarega na eriko poku mu ne afenyo make mo to aba. I don't know the yama be quite MP to be.
Say enti ano no nkyere se obi a obetna speaker nan mu bia no.
On to be to aba. Obi. Ye no bi ka se bi on.
Eno no nkyere se obi obetna speaker nan mu bia no. Nioma speaker ntumi nye bia ono nso ntumi nye. Because the chairman etna speaker name at the committee, but at the committee, no, obetimi our casting vote. But speaker ne the only casting vote.
Into one, you are right. Now me say, oh, bad deputy speaker no so. Standing order. And now you say casting vote from our constitution and the amount we standing order and the amount.
Absolutely.
I don't know the young case in the constitution in the Supreme Court.
Are
you getting me? And I say, when it came to deputy speaker, no standing order, and say, Momo dear, Muni original vote.
Yes.
Supreme Court to say, Parliament, one and more kinds of Moyamra. And so we did a Papa Yabogu. Okay. And Mraben, the constitution, Nimuso and any Bobra, Yentubinka.
Mate.
I said, what did that?
Or say, there is so much absurdity in the submission that an MP duly elected should not perform his or her primary functions merely because he has an added responsibility of being a deputy speaker. That Samuel Brian Boabin, Adam Fona, or Kanehwasem. Obi, good afternoon. I agree with the Supreme Court 100% regardless. Let me thank Ekria Boachua Yadom for introducing a very important topic on her show last week regarding change or amendment of our constitution. There are a lot of works that need to be done in our constitution. We have to start thinking about changing or amending the constitution now. Master Planner Junior. Ewo King.
Now, US, you know. US, because I was an honorable person, best Adaji will do because maybe I paid $20 and I was here. Kagan, the Ghana come so that the air can article, then will be with you cry your confusion. Oh. Honorable Jogati can be in discussing this issue as to whether or not Ghana deputy speaker and deputy speaker with me to abide it me kind of as part of quorum for ebeya yemfa amamaya what practices and because of maybe in the system of democracy.
That's true. Yes,
US House of Representatives President currently Nancy Pelosi or not Yebemua or ye debate or tuaba. Because US force system. The US force system is a partisan system. Yeah. That is why the president of the House of Representatives is from the majority party. So he's young. Are you getting me? Yeah. He's not there as a neutral arbiter. He's a member of parliament, and then the deputy. So no one can a member of parliament from the majority side, and only the majority. Not he's more or less like the leader of the house. But UK is a different system. The Westminster system is not pure Westminster system. UK House of Commons and no Parliament. Currently, Sir Lindsay host and a speaker. Or a member of Parliament for Chorley.
Yes.
But Twaba. It's UK for so disenfranchise it almost speaker of Parliament. So, country be able on the system. That is why what I am surprised and they say the president will seek. Say president example no here with presiding member and say I'm part the end say I'm part the presiding member at assembly too about all original vote there and you can be a solid point. Say Ghana crown here was system bisa at the local assembly level.
Because you said presiding of all.
Only original votes. Only original votes. Only original votes. It's a president vote. Only original votes. And head of the parliament today. Head of the parliament to all original votes. We don't have that system in Ghana.
Let's listen to the president.
And then the bro for the Wakabia chair for slides. Hey,
Nana Adodankwa Akufo-Addo, President of the Republic of Ghana. His views on the Supreme Court ruling.
Let me begin first of all by saying that as a rule, I've made it a point since I became president, as much as possible, not to comment on constitutional issues in the country. I think people who are students of our constitutional law, our constitutional jurisprudence, are very much aware of the role that I played
Ekosiisen on Asempa FM
in helping define some of its basic principles of interpretation. And I think that now I become president, if every time there's a constitutional matter I'm here to pronounce on it, it will give the impression that I'm setting myself up as what, some sort of rival Supreme Court. And I've been very reluctant to do that for that reason. I think the body that the Constitution has set up to be responsible for declaring the meaning of the Constitution, interpreting and enforcing it, is the Supreme Court, is the judiciary, with the Supreme Court at its apex. And as a matter of good governance, it's better that that body, which has been given this exclusive power, is the one that is heard on constitutional issues. And that's the reason why I've not been open or vocal on but I think this one, I feel strongly that I should make some comment. Firstly, the noise that was generated on this, at the time I was extremely surprised because as far as I can see it, and I think the Supreme Court has confirmed it, the matters involved in this thing are open and shut. They're black and white. There can be no dispute about the issues that the gentleman took to the Supreme Court. It is there for anybody who wants to see. In Articles 102, Articles 104 of the Constitution makes it absolutely clear in black and white that the deputy speakers, I'm not speaking of the speaker, I mean the deputy speakers, when they're presiding, have the right to participate in the vote of the parliament. The whole structure of the Constitution, and indeed, and I believe that would have been part of the reasoning of the court, all the legislatures of the world where the presiding person is a member of the legislature, like our deputy speakers are, like the Speaker of the House of Representatives in the United States, or the President pro tem of the Senate in the United States, or the Speaker of the British Parliament. All of those have the right to speak because they are members of the Assembly. Our Speaker is expressly not a member of the Assembly. That's why he doesn't have the right to vote. In fact, he really ought not even to participate in the deliberations of the House. He's a referee, making sure that the debate is conducted properly and that the rules of procedure, the orders of the House are complied with. That's his role. But he ought, strictly speaking, not to be part of the proceedings of the House. That is not the case with the deputy speakers. And that matter is transparent on the face of our Constitution. Indeed, even the presiding members of our district assemblies, they have the right to vote. Look at the district assembly law, because they are members of the assembly. And once you are a member of the assembly, you're representing certain constituencies. If you are denied the right to vote, it will mean it is tantamount to denying the right of the people you represent to have a say in the decision of the assembly. That would not be right. So I couldn't understand what all of this furore and controversy that was artificially generated. We're being told that the decision of the court amounts to judicial interference in the work of Parliament. I'm not quite sure that the people who are saying this have actually taken the time to read the Constitution of our country. It says so in black and white. The legislative power of Parliament that is vested, of the state which is vested in Parliament, is subject to the provisions of the Constitution. All organs of the Ghanaian state, including me as the head of the executive, we are all subject to the teachings of the Constitution. There's no body in the Ghanaian state that is above the fundamental law of the land. It would lead to the very matter that we have striven so long to avoid, the concentration of power, of unregulated power in our state. We don't want that. We've had that experience before, and we brought about this constitution in order not to allow that to reoccur. So I'm astonished about how much public energy has been wasted, I would say so with the greatest of respect, been wasted in an area, on an issue where there is so much clarity. And I'm happy that the court, and I'm sure as you're aware, the Supreme Court, when it is declaring the meaning of the Constitution, and it does so unanimously, that is the most emphatic way in which the court can pronounce. And it is, I believe, a decision of 7 of the judges, and a unanimous decision declaring what the constitutional position is. I think we have an opportunity now to put this matter to rest and continue with the work of our parliament and the work of the ordering of our state. But as I say, I suspect that it is this peculiar position which we are, with this very line majority in the parliament that has given rise to all of these disputations and people making claims that are completely beyond the teachings of the Constitution and our understanding. But now that the Supreme Court has pronounced, I think what is required is for the nation, all of us, to get to put that matter behind us and to do our work. To suggest that somehow or other the Parliament is beyond the scrutiny of the Supreme Court when issues of interpretation is to suggest that Parliament is a law in itself. The whole principle of judicial review was developed by the judges, both in America and in England, to be able to check the activities of Parliament. Indeed, in our own country, the first major constitutional case which looked at the work of Parliament was in the case Tufo and the Attorney General, where the act of Parliament, the decision of the Parliament to subject the then Chief Justice, the late Frederick Kwesi Apalu, to a vetting process in Parliament, had been expressly forbidden by the Constitution. And that is the reason why Dr. Amaku Tufo, the late Dr. Amaku Tufo, unfortunately late, took the matter to the Supreme Court. And the Supreme Court made it quite clear that all the activities of all the institutions of our republic that impugn, that violate the Constitution are subject to the powers of the court and to the declarations of the court. Me, I want to repeat it, President, head of the executive, I am subject to the Constitution and to law. I cannot set myself above it. Everybody has his remit, but those remits are subject to the operations of the Constitution. And I'm happy that the Constitution has been so declared in such an emphatic manner by the Supreme Court. Let's support the Supreme Court to continue to do its work. And I'm hoping that I'll not have an occasion again to pronounce on constitutional matters.
Thank you very much, Mr. President.
Thank you very much indeed. Yeah.
Asempa FM.
Nana Adodankwa Akufo-Addo, President of the Republic of Ghana, sharing his opinions on the Supreme Court ruling into Wakan Sembebre about constitutional jurisprudence and yes.
Okay, the 5 minutes we're born upon that your concept for so. You know, Biaka say, be anywhere what constitution ni more. A casse, in first deputy speaker. Inise Otwaba. It is a parliament ko yes amrana eni nyina so bia. And am mo hu say anywhere unim say judiciary na nkasa kwa constitution am mo tumi so mo ye mra to govern or to regulate the course.
Rules of court,
CI 47, CICC ni nyina no judicial you say is the judicial arm of government and CI 40, GYAMFI High Court Civil Procedure Rules. CI 47, the Umubia no Constitution. It's not, you can't even have it that way. It's not possible to have High Court Civil Procedure Rules in the Constitution. And are you going to say, sir, judiciary require CI 47 and not a regulating High Court Civil Proceedings? Provisions in the Constitution means your own Constitution.
But when you need to say, if there is a provision in a subsidiary law which sins not just against the letter of the Constitution, but even the spirit of the Constitution, the Supreme Court has the power to declare.
So if we are looking at the
I
letter,
cannot pinpoint it now.
Not now in Niho.
No, say I was see a chairman ruling never.
That's the point.
Maybe they will.
Maybe our body will say, well, okay, we are waiting for
the reasoning.
But to say the Constitution in the letter you baby say deputy speaker to me to Aba.
And I say on to me to Aba.
I know the name, but they say Supreme Court. So that's number one. I make sure say the spirit now. What can I say? A constitution which provides at Article 102 that a deputy speaker or any person presiding cannot be counted as part of quorum. And when there was a war answer na parliament, a better as our constitution, like I say, the all presiding Afigya do about what to be.
Okay.
Are you getting me? So that's the spirit of the law argument will not come in. Rather, the spirit of the law rather favors the argument. Say framers of the constitution, they say, quorum to even transact business. You know, Deputy Speaker while he's presiding there. Then clearly they also intend they say in that proceeding now, yeah, can quorum are you getting what I'm trying to say? So then
former President Mahama signed a post.
yes.
This time on the post they say if deputy speakers, because they are members of parliament, can vote while presiding as speakers, they could as well be able to participate in any debate on the floor over which they are presiding. This is the absurdity into which the Supreme Court ruling.
That's it.
leads us.
Because
John
who ya tuaba ya me patro oh the honorable is solid because you see ya tuaba ma.
No, but
Afigya Kwabre not.
The word absurdity. I think he's a former president.
Oh no absurdity
No. I think
a lawyer for the you can't no lawyer you can't no. When you are criticizing a court decision, you use words like unreasonable, absurd, flawed. All these things are words that are used. No, I've said the chair saying. You are not being fair. You see, I've said as someone and to assume which is decision is yes, the end point, you know, ridiculous. Wow, imagine
to him.
But honorable, one can say imagine Deputy Speaker Teardrum. Near debate, no pijanesa. Ghana, a pijanesa, or say my friend, me home, and me babeka. No, I was sorry, now.
The ruling does not say that. Why are you important?
Let me tell you, Deputy Speaker, MP, into one about the ACM and into about their parliament for 30 years in the moment. And then he levy a bentino, they say, Assembly court, yes, say. The Deputy Speaker no Antwaba and yet say you chrome for no are not having a say in decision making. I mean just say MP no majuman kwan so motwaba. In fact, 90% of what they do on the floor are deliberations.
Yes.
We move motion, now we debate, now we put it to now we a lawyer for na put it to you. We point of order na de keka ho. Are you getting me?
But that is not what was before the Supreme Court.
And I may say, yes, we all know that. But the logic of this decision, it means if we put this one before them too, they must rule that he must participate.
Then put it
in
the
debate. They are not
bound by
that.
So then you are having a Supreme Court who will give inconsistent decisions based on what they find convenient or not. And yes, sir, so the law must be certain. But President Mahama
former President Mahama again. A unanimous 7-0, shocking but not surprising. An unfortunate interpretation for convenience that set a dangerous precedent of judicial interference in parliamentary procedure.
100% correct. 100% correct. If Justice Sowa was alive, this is what he would have said. The Justice Sowa who read the ruling in the case of Tufo versus Attorney General. If Justice Pega, he is one of the, I can say, the foremost defender of the political question doctrine in our jurisprudence. If he was alive, we know better. Because you see, yes, say, Uma president, who is the head of the executive, to me, discretion be so onye bibi. Now, otra di emrane so onye di court bebem. But said the all you know. Within that discretion on Tiambrano so court it is the same thing with parliament. The parliament for IABB any constitution about Brana court to Shegua. Obi no betumi akasa. For example, constitution see deputy speaker betumi to abana parliament say no. Obi so say and I will text the can be say say woka say and my deputy speaker and Tuaba you are the same franchise. I mean deal with that. Oh. My can show order 2115. I am my chairman of a parliamentary committee at the committee level and Tuaba, even though he's an MP on the original votes.
Or casting vote.
Okay.
But
casting vote, they make me say
on
at least only original vote. Okay. Yamra Article 104 clause 5.
Yes.
Article 104 clause 5 say
a member who is a party to or a partner in a firm which is a party to a contract where the government shall declare his interest and shall not vote on any question relating to that contract.
And unti say argument na man for you correct say MPBA representing constituency. In the assembly of Bamrashe Baby and there was ultimately 2 swababia. I didn't know more constitution at Article 104 clause 5 say. Assembly ba. Now who MP no assembly buy no. A contractor who na one a buying ISR contract no. And I babetom Rashe Baby for him. And I also yam Rashe Baby ni. And I say a company be near buying work contract. And I wo shares and now your partner was our company anymore. Contract na ababetom Rashe Baby for him na. Rashe Baby for ababeto swabano. O ye MP. O representing constituency. But untimin to swab baby. Obi, Adentia. And then they understand the argument and they say, even though I have an interest in the contract, no, I am representing my people. It is why Mama Kwai Mama Twaba, you are disenfranchising my people. Adentia. Because
it's a conflict of interest.
Yes, it's the same conflict of interest. My good.
Where the
conflict of interest, they saying because we am Rashe Baby ni, ye be Twaba e wo contract wo interest with me boy. Good. Enti Joe Wise.
Yes.
We are MPP ni, and I am Rashe Bedwani. Wo support to e-levy. Tieni yo. Ye betu e-levy swaba. Wo na wo tie dwamu a. Obi a motion on e-levy a wo na obetimi admit.
Yeah.
E-levy bill ne kra no ye amendment bi a wo tie dwamu no, wo na obetimi obetimi admit and obebo agu. Me boa. Provisions, whether amendment, whether motion, whether the NDC needed sorry no person okasa kra wo na we recognizing and say we tumi akasa.
Yes.
Are you not conflicted? You are conflicted because you have an interest in the e-levy.
But that
Just as the member of parliament who is a partner in a firm or a government or contract number parliament and him for which reason yes you interest or contract in mutibane to abano. Wo sa deputy speaker no wo interest wo e-levy mu a wo pese parliament pass na wo so na wo ba be interpreting rules. Oba be ruling on motions, oba recognizing nipa mo makasa, oba admit amendments ne de keka ho no. Wo so ba beto abani bia. Are you not conflicted?
So it's
a principle.
No, a stretch of that point would mean, sir, heads of our various constitutional bodies, especially the Electoral Commission, should be barred from voting.
No.
Why
Don't
no?
go there. Don't go there.
That's also
Because easy for any CIBR almost say match a person to aba.
No, I don't
And
mean
a check.
no sense. Yeah, you
conflict yes.
You reference 1045, and by that stretch now, what they are
I think I maybe raise that.
would mean that the Electoral Commissioner should not vote.
No, you're not getting me. In the case of the Deputy Speaker SAMMY, you have an interest in the subject about winning.
Yes.
Then you have the power. You are given discretionary power. To rule on motions, to recognize somebody who will speak and not. Is that the same discretionary power given to the EC chairperson?
But that discretionary power,
EC chairperson
296 is clear. So you cannot exercise.
Hey, Master, speaker, dear Jemua, Michael Quay.
And arbitrary.
Right honorable speaker, and arbitrary, Michael Quay, Muntakabit Miaso Reginan and answer as whip for the then minority. 5 minutes, Michael Quay is me. No, because I don't Mutakaja, Mr. Speaker. You know, Parliament. So the point I'm making, and let me even interrogate, example now, woman.
Yes.
In the case of Parliament, dear, Parliament say, yeah, system of parliamentary democracy now you use, the one presiding must be an umpire, meaning say, what you drum as judge ni, it was so jina, or was so yadantemu, it was so jina finfin. It is so jina will be a fan. At least maintain that outlook of neutrality and impartial. That is a system.
Okay.
When it comes to the EC chairperson, it is the same. But EC chairperson
Very well.
But in the case of deputy speaker, person would so two different things. But maybe finally the mechanic and say some of us we are officers of the court, young at the bar. We don't pretend to know better than justices of the Supreme Court. But you see, Honorable Kansembi also Supreme Court na better be decided it. No correct. But Maza, there's been so many occasions in the history of this country and in the history of other countries. Supreme Court, Omodia Temuaba Batemra,
Reakoto.
Yes. Unanimous here. To me, the unanimous decisions there. Unanimous here. And the 7 others are caught under Preventive Detention Act. yeah, without trial, yeah, detaining or more because Nkrumah say Nkrofo yomu ya wudi for. JB Danko, o man penye Kufuor ne wo fa JB Danko mo de assembly court. Say maza, o hwe sa 1960 constitution na. Na hwe ota President Nkrumah swear na. Wa swear say obe uphold human rights. Supreme Court ne say sa oath na President Nkrumah swear no. Enye human right provision eno de say Queen of England the coronation oath no enti eno de enye ohye opando this one unanimous service eno ene ajaje fo na nkasa ene a lawyer fo ye twabo judges ni de bia say
almost like as a PDA and so parliament na ejitum
parliament ejitum but that one they were right. Me have defended that because under that constitution parliament was sovereign, but now parliament is not sovereign. Are you getting me? So the point is that court aye bibi nti nyina ye nyuntu no, me I don't buy that. And we can criticize the court even in very harsh terms. And you can criticize the court because for me this decision it will lead to a lot of disagreements, and if we don't take a chaos in parliament. And that is why I'm encouraging your members of parliament. You see, honorable there or majority. Hey, Omunya Botre was same way home. Honorable or majority, the abe there. It's on the back say, Sammy GYAMFI mu MPs no asem no mo kana no ehye do besenka on the duana mu am o dan nti no se kwan netene. But me point I make nyina ne say our MPs, I'm happy they are standing up. I'm happy they are speaking up. Obian kasentia court no. Almost say there are three arms of government. Mu interpreti mra, yeso ye shemra. Say ye shemra ne tia mra mutimi bam. Ye mra ya she di ntia mra bia mu ni wo kwan say modem ho for the adwuma. But on the floor of the house, members of parliament have immunity. And so if their interpretation of the standing orders of parliament is that a deputy speaker cannot vote, and article 3 and article 2 when you high treason if it is on the floor of parliament, okay, I must remember another provision on the floor of parliament until bringing any criminal or civil proceedings against an MP for a same or and for idea on the floor. And honorable, you should support that position because you see and they were opposition. But one guy who said the Nyama is an Amamoya is you are on your way out. And I also said it was about home modern over swap parliament. And you obviously be in that opposition in the next parliament. It's your best accept the independence of parliament. Parliament should never accept this. They should go for review, but even on the floor, they should accept their independence.
2-4 no. Failure to obey or carry out the terms of an order or direction made or given under clause 2 of this article. And clause 2 no naturally say Supreme Court no power.
But let me show you why you can do that.
To declare or say of this article constitute a high crime under this constitution and shall, in the case of the president or the vice, constitute a ground for removal from office under this constitution. For other public officers, Nimpodie, a 10 years imprisonment, and after that you are not even eligible.
Two things you must know.
For election.
Now one kind of provision will be if we it's SAMMY GYAMFI mu niye kasa dia you can read it. But when we are talking about Honorable Sam George ni MPs more, you don't read it. It's number one. The Supreme Court must have made an order or must have directed somebody to do something.
Yes.
And these MPs were not parties to that action. No order has been made against them. Said they should do something or refrain from doing something, for which reason you can hold them in breach of a Supreme Court order. That's number one. Number two, if member of parliament be outside parliament, it defy the express directives or orders of the court, and they are high treason. But on the floor of parliament, and they have total immunity.
Defy the Supreme Court.
I won't call that defiance. I will call that they are asserting their independence and they're sticking to the correct meaning and interpretation of that.
Me say same way. See your question say the be obey interpreted the obey count the come there. Oh, be other candidate. Me 1045 asema no can about this. You know, I disagree with Sammy. I mean 1045 no can about conflict of it's so clear. Show me what committee. No, we a board member one state. Yes. I have to declare to the committee, say, I'm a board member. Yeah, there's nothing wrong with that. a constitution e kan e clear untimi nye a party to you know about the approve
Now guys don't send a message.
Electoral Commission, chairperson of Electoral Commission, be no bit me stand the elections. So one conflict of interest.
Absolutely.
Even do so your Ghana.
Absolutely.
It was a brand new.
Yeah.
so I know the menace and then president speech just many Sammy Kasano was president can't draw back or can't draw me no or church him. Me see president voice no draw be no can. Oh dear, draw be na president try.
So say assembly presiding members will vote.
Na presiding member only casting vote. Presiding member casting vote.
The spirit behind winning your original.
No, president Ghana who now be interpreting president say spirit and a letter. The president did not make any mistake. As some president can nobody be him. It's now lost. Presiding member no casting vote. So there's nothing wrong with say we try and draw and as we try and draw. So try and draw and draw. I didn't see that. The president spoke the truth. There's nothing wrong with Asama president kind. On the course was it Hope said this will be the last time he will comment on this kind of this kind of issue. Again, Asama court. Me sure say e-levy Asama the court. Sammy Kasabia and 11 me sure Sammy. Asama court. There was nowhere a woman say 11 in the court. They came for an interpretation.
If I know even on the budget, rather than
it had nothing to do. Oh, it has nothing to do with the e-levy. Assembly by the court assembly, Supreme Court ruling about e-levy assembly. It was just an intellectual EBA course. And nobody ruling about. Some would disagree, some agree. And then we said, okay, Joe got a very senior lawyer. He was making very sound arguments. I've also listened to other people who making other arguments. Bottom line, so far say you are aggrieved that go back for a review of the whole decision.
Okay, some few messages and then we close the book on this. Now for Yatuaso, Obi ask lawyer Sammy, why does a member elected as speaker lose his seat? But deputy speaker stricto sensu must be an MP. That's from James Kwabre. He again says, Article 97 1B and Article 96 1A and B. We cannot choose which decisions of the Supreme Court to respect or not. The Supreme Court is clothed with the power to do what they did. If you are dissatisfied, it does not make it right. Parliament was not sovereign under Nkrumah. Correct him, please. Ask Sammy if he is suggesting that Parliament can choose which decision of the Supreme Court to obey. James Kwabena. Sammy, note it. I'm coming. Note it. Obi, good evening. Please educate me. Is law not founded on common sense? If it is, then why would the Supreme Court rule that the referee takes a penalty kick? Interesting times ahead. Greetings to Sammy GYAMFI. Law founded on common sense, and yet always law is founded on law. A law, Emra.
He can take a penalty kick, but he cannot take part in the game. He can't play.
Yeah, he cannot play.
Because now he can't debate, but you do vote to the
Obi, the Electoral Commissioner has no interest in any of the political parties. EC Commissioner is supposed to be neutral, unlike the Deputy Speaker who belongs to a party and has an interest. The two cases are different. Yayira Koku and Odiwe Abba. We say, Obi, is the contract personal to the MP and where a contract in 1045? No? Is the contract personal to the MP or beneficial to his constituents? And that's a question from Abdul Malik Kwekubako. Or said, does the contract have anything to do with his constituent and constituency, or it is his personal matter? Yes. You get his question?
It's a very valid question.
Yeah.
So that even if the contract
a member who is a party to or a partner in a firm.
It is personal.
A personal.
No.
In
So
a
it
firm,
can be personal.
which is a party to a contract.
Good. So
which
now,
is a party to a
now
contract.
To why he may be
With the
asking
government shall declare his interest and shall not vote on any question relating to the contract.
So even though the interest in that contract may be a personal interest, no, yes, and that will affect his constituency. Article 1045 say
on the basis of a contractor or yet
personally, but he's not there for himself, he's there for a constituency. So why won't he be allowed to vote for his constituency? Because the contract is not the interest of his constituency. It is his personal interest. So why is he barred from voting even though he's representing a constituency? You see, it is because to say they have seen that as an individual, once you are conflicted, you can't vote. Whether you represent a constituency or not is immaterial to Article 104.5.
Dr. Bernard Okoboy says, Obi.
Text messages. The whole of this year, one will TV so and I radio so baby.
Honorable Jogate told you that he presided over matters, and at the point of voting, Speaker Ajaho took over so he could vote. On the same issue he presided, left for Ajaho to preside and participated in voting. In this parliament, Joe Wise presides over a matter. Second deputy takes over so he could go and vote as MP. And then the NDC says, boy, what is the difference between what happened under Doa Ajaho and Joe Wise being replaced and being replaced by second speaker so he could vote? The NDC is pushing hard to make us believe that an MP who is presiding should never attempt to allow himself to be relieved by another, so his representative right is lost. This is the purposive interpretation that the courts have given. Parliament cannot take away the representative right. Oh, Toboe. And I said the mischief rule. Parliament cannot take away the representative right of a member of parliament under the guise of a standing order. The law which takes away the vote of the MP who is presiding is void in accordance with Article 1-2 of the 1992 Constitution. In Tofo versus Attorney General, the court discharged the Speaker. In Tofo versus the Attorney General, the court discharged the Speaker since Parliament had the right to engage in processes they believed was right. But the court invalidated the averting and purported rejection of Justice Apalu. If the court then could write off the vetting and pronounce the action of Parliament void, why can't they today make a statement on the validity of a standing order? In a constitutional era, the institutions set up by the Constitution can act in a way, but when that way is challenged, it is the courts that decide on the rightness or wrongness. It is not within the jurisdiction of a political party to tell us what an inferior law means. Dr. Bernard Okoboy.
Fantastic.
Senior
Doctor.
Daddy.
Yes. Dr. Okoboy, our expertise in so many things.
Senior Daddy.
But now a student, that's what you don't know.
He's not a student of law. Wow. Congratulations, Doc. Congratulations. But my mentor not doing CBB so.
Yes.
What my dream, I disagree with him on one thing. Or say, Honorable Jogati can say, or no yet deputy speaker no. Now we to miss from Ekotoaba as a member. Now Honorable Joe Ajaho presiding. Now what is the difference between a non Joe Wise person on the second deputy? I mean shown because number one, Joe Ajaho. Number one,
Do Ajaho
was a speaker, not a second deputy speaker. Okay, so
it doesn't defeat the principle.
No. I will explain something to you. The man, Honorable Joe Wise, there near unacceptable. They say Honorable Joe Wise there no. What motion? What put a question on a motion? And they are voice votes. 1-2 voice votes nibi. Or say as many as are in favor say aye and now maka aye MPP for aka. As many as are against say no and NDC for aka no. Joe Wise 1-2 be. And now Honorable Muntaka challenge vote no. And yes, okay. Deputy Speaker, I will say, I for no, and no money, I was trying to more, the eyes have it. But we think that the no was louder. So now you be a division, she say, or more to I, no, ye babe kind of mo. Now more to no, ya kind of so. Who speaker now would tear Jamuna 1-2 I nibino, was a me see for mam yaka I for no. At the point of division. And yet, any Jogate, the other if Jogate was presiding as a deputy speaker,
which he was,
and before a question will be put on a motion, he goes down for the main speaker to come and sit
and put the question,
and he participates in the voice vote. He can vote during the head count or the division because he was part of the voice vote. Into honorable Kubo into one I say. I feel to 4 versus Attorney General, Minuano. Is there no Obia, I feel all law school
first semester.
Now say or your constitutional law fresh. Into ne obey the no sharp a chair median because ne near fresh. But if for nothing at all, I remember one thing. The case did not go in favor of Justice Apalu and the plaintiff to 4 because the Supreme Court annulled the purported nomination and vetting of Justice Apalu. Supreme Court and meddle in parliamentary exercise. What they said was that the relevant provision of the Constitution, which was the main issue, or the main bone of contention, has said all those justices of the Supreme Court, upon the coming into force of the 1979 Constitution, shall be deemed to be appointed. So that shall be deemed to be appointed, and the Supreme Court interfere. Say when Justice Apalu was giving the certificate, your man is a krata, at that point he was deemed as the Chief Justice. And you know, here any nomination or vetting BM, the Supreme Court, Justice Sowa, kind of decision now, he did not specifically annul the nomination or the vetting. And that is why I can say the parliamentary it is a closed book. They will not inquire into that because Parliament but they interpreted the law as it was. The Kenyan say
okay.
The Kenyan say the totality.
I think the Kenyan say yen train or chana detailed ruling.
I don't see how the detailed ruling. I would like to read it, but it will even make things worse for the Supreme Court, and they make a down because they will struggle to find any provision in the 1992 Constitution which order 1093
all the 7 justices of the court.
Now more real justices of Supreme Court. Unim bad decisions at Supreme Court over making. Why do you can't pay inquiry? Why is the Supreme Court pay inquiry?
A mistake.
When the Supreme Court or when a court makes a decision without regard for law, that is pay inquiry. Unim pay inquiry decisions at Supreme Court are making in the history of this country. You can't count them. So Supreme Court, they make decisions that are per incurium, that are without regard for law. They make it all the time. So you guys should not create the impression that the court is sacrosanct. Their decisions
they
are
cannot be. They cannot be. How can the Supreme Court be sacrosanct when there is inherently
and I said Uzi woman 7 justices of the Supreme Court in
what's the assemble kumponka from the country.
When you say 7 in what your friend phone so na bisa me say obi wa kan awie won provision bi wo mu a omo say order 109.3 na nyamra papa no mahie gu na ne bo abrana obi emre eko ye sorry ye make nyina na say ye make nyina na say Ghana for bre nkomo a ye di nyina Ghana ni a wutie wo de wo mu ma wo take away ne say E11 na eba e de ahokyere ne abenidie ba beto so ama wa bre no buy no ye mumu a omo betu sika obi de sika fra bruchiri ba ye betu sika e ba be bu ye komu after maybe na petrol twem 37 Ghana cedis per gallon dollar ne nam 7 cedis 70% de keka ho nyina echi no o man penye kufu ado ne na ban aye o madwen se dole e wo se E11 de baso NDC for ye se yem pene so e no mo se kwan a E11 betumi afa so abaso ne se yem pe kwan bi so ne yema deputy speaker tie aduam no kwan no to aba asem we nyina ni na you know that this decision what it means ne say
no but the Supreme Court did not consider
E11. I haven't said the Supreme Court considered this E11. I am saying that yakwa DNA majo why is ka so beto aba it was over the approval of the budget. Why was there contention over the approval of the budget? The main issue was the E11. And the asem we nyina ne fare by any E11 MPP for whom they say deputy speaker enya kwenya so betimi ato aba it makes it easier for them to pass the E11. Let's not play the ostrich. That is their game plan. By the ye catch almo say deputy speaker betimi ato aba untimi nto aba o E11 ya mutu onyame ne omo kasa 138 no munya ne nya ne kina
nempa ye nemem nempa ye we a o nyame ne egbo first of all no let me assure me nia penye say this decision free Supreme Court no enye ye MPP for na say be sha say chinchina ache ye pese pass E11 the Supreme Court enye 7-0 Then this they are used to the 7-0. Okay, court case. 7-0 they are used to it. It's yes, I Sammy, what can I say? You are used to the 7-0. When can say I mean, who call now the strong case? I'm sure the judges will be professional. And in this case, no, I didn't make us say a bayer, make us me support. Ubeka said the argument to be back and forth. You're trying for the reason in Wachna. You really share reason no. Me, I'm quite confident. Say the Supreme Court 7 in for or against the without any good reason. There should be a reason. And me sure say Sammy, a banner says Sammy reading in area, his arguments probably will change.
Yeah, plaintiff Nekraka said, depending on the reasoning, he would consider going for a review or not.
You know, me sure say at this particular moment,
Yes, deputy speakers there, because they must represent their constituencies. But Krobidao, 4 communities, Sal, they are not even represented. That is how this matter smacks of injustice.
Okay. We say Obi, tell Sammy that even in error, decisions of the Supreme Court is law. James Kwabena Bonfair. We say Obi, it is not compulsory for an MP to participate in a debate in the August House. I'm not sure former President Mahama authorized those unpresidential posts on Facebook.
Already the arguments of Geoffrey Bing, if I've not missed the name, who was the Attorney General for Osaje for Dr. Kwame Nkrumah, and
in Reakoto.
In Reakoto, yes. His argument basically was that under that constitution, Parliament was sovereign, and the court could not question what they had done by passing the Preventive Detention Act. Okay. I know what I'm talking about.
That's.
Let me repeat. And World Kidney Day.
Yeah, World Kidney Day.
Say there are a lot of challenges.
Is there kidney issues?
Very, very. And then me a statement. A little research with the renowned department. Yeah. Obi. And easy, sir. Mr. Say you take your health very, very carefully. The kind of costa.
Associated young guys kidney, minimum more dialysis.
Very, very serious. And just yesterday, Alberta Ashley. Yeah. Abigail Ashley, lady now surviving, or money every month 4,500 just for drugs after the transplant, consistently.
That is maybe about say kidney now because dialysis.
Dialysis. When
dialysis, no, from my investigations, no, say okoso one and mostly twice a week.
Yes.
One biano, I think close to 300 Ghana cedis.
Yes.
And we 2 every week 600 cedis. And overall dialysis until you do the transplant. That is when we be my name mount. Yes. Be cry. If you ever say what for about 5 years. I think when you share cow every week.
And the little research, you need about almost 50-something thousand Ghana for a year.
For a year. For a year. For dialysis. Yes. And then after transplant, the new for the rest of your life.
For your life. In fact, Abigail, Ghana. The problem is that the dialysis machines, it's almost 70% and you can imagine so what the constituency they are diagnosed with a kidney. It's a major problem.
Private jet 7.
Very interesting point in my research and a statement I'm making. It was one of the points I'm making. The concoctions, and the problem, most of the time, be detected on an advanced stage because when you be any concoction, time will be say. United say
a member school manpower
it is here drobia
and they working the message
the rate of becoming remember young guys too and they are weak. Who say dialysis in this one? Never say we call every week in Puna Obefia. You become one and take it to be an abrev. It's not serious.
Of course.
It's not serious. And Madame Bagum cry me name there. Charlie, no, one year in on donating the kidney back home, no. ono ane ye chale
Yeah, and send me brave.
And you need a donor ne system no system match.
I
Ahwe and a constant checkup. Is our checkup your kidney will liver.
Checkup. Me I cry me di hufo.
Yeah.
Exercises.
Check up there was so tired. I was so tired. So tired.
You be a ya can Kenya say ke be am port for. It's $1 no be baby e corner no day. 70 pesos. Man pinya be the doctor ba we so krum ha we enter in car. Em say say crowd we 2 bata.
SAMMY GYAMFI and I say the can. Ekosiisen so ni. Na what is we 2 kwan.
Me because we 2 bata and we run na Zimbabwe ama Gideon kwa. Because Gideon kwa na maintain car. Na ba say me hu no kra ye hu